18th of June 2025, sorry. We are happy to announce to the world that the prosecution has finally closed their case today with their last witness, PW5, known as EEE. He came and tendered reports of the NSAS, and in the course of the reporting, he alleged that it was the statements made by Mazi Nnamdi Kanu that instigated the damages during the NSAS. And he was subjected to a thorough cross-examination by the defense team under Mazi Bazu. And as God will have it, we are happy to announce to you that so many things went wrong with his report, including the fact that not even the signature of the chairman or the name of the chairman or the secretary of the report of the committee he claimed to represent was found in the entire report. We are happy to announce to all lovers of freedom that the matter has been adjourned to the 18th of July 2025 for a no-case submission. In other words, to tell the court and to show to the court that the prosecution merely wasted 10 years of Mazi Nnamdi Kanu's life by arresting and detaining him for no just cause. So we are happy. We have very short time within which to work. We are going to utilize that very short time and make sure we deliver on our mandate. And our mandate is to provide sufficient defense for Mazi Nnamdi Kanu. Thank you and God bless you.
All right. Thank you. Thank you very much.
Yes. Well, I am very excited to be here as always, even though, as usual, the DSS prevented me from entering the courtroom. But I'm a living witness to history. The first time Mazi was abducted from Kenya and brought here, I was in court to warn them that, in fact, I was one of the few people that came here as soon as they did their kangaroo arraignment, that this case is not going anywhere, and that there's no way, it doesn't matter how long it takes, it's going to end up the way it started, as nothing, and it will end up as nothing, because there's nothing that can stand up on nothing. The foundation of this was malice. It was a suppression of a section of Nigerian people and a violation of the fundamental right of a Nigerian British citizen who was abducted from another country, brought here without due process and detained indefinitely, even presented from having open and fair trial, which we have seen all over the time. As a matter of fact, today we already had an altercation with the DSS preventing people from moving around here. But you know, they started by blocking everywhere. Now they are tired, they can't even block half of the road because you cannot stop an idea whose time is come. And this is what we want them. And I'm glad that they are reaching the dead end that we have predicted. The dead end is that there will be a no-case submission. In fact, I would have an issue with the lawyers if I were to be involved, because there's no need to even file a no-case submission in a case that never existed in the first place. But you have to do your own legal work. And let me use this opportunity to also appreciate all the lawyers and all the people who have stood in solidarity with Nnamdi Kanu. I've said it that if I'm the last person that will stand with him, I will stand with him. And mine is not political. In fact, the most unpopular political decision to take in Nigeria is to stand with Nnamdi Kanu. So if you want to win an election, you know who to stand with, which is the federal government. But I'm not doing this to win an election. I'm doing it for the freedom of our people everywhere we might find ourselves. And I believe that if Nigeria is going to become one, it has to be on the basis of justice. We cannot be suppressing a section just as the rest will flourish and think that you can go home to rest. And you have seen it now. Even those people who never believed Nnamdi Kanu a few years ago, they have seen it with what the Fulani herdsmen are doing, killing hundreds of people. They are doing it also in the southeast. They've killed in Ebonyi, they've killed in Enugu, they are killing in Edo, they are killing in Kogi, they are killing people across the country. Imo, yes, there was some killing. So this was what Nnamdi Kanu told you as a prophet. But he has always told me, when I met him in New York, that he's not a prophet. He's just saying the reality of what the Nigerian project is all about. That it was a fake project put together and it can never materialize until there is justice. And this is what we keep advising them. The interesting thing was that there was even a time in 2019 that they charged me secretly with him. I filed a charge here that I connived with him to kill some policemen. So the case never came to trial, and it will never be. So we can't wait to see Nnamdi Kanu rejoin all of us.
All right,
and I'm very certain that will happen. Sure. It's just a matter of time. Yeah. And it doesn't matter how long they do their case, which I never believed in that.
Wow. Greetings to everybody watching this video. That from the beginning has not been able to discharge the burden placed on it by the law, that the case be proven beyond reasonable doubt. That is our position. That is our position as a defense team, and that position will be reduced in writing and filed with the court within 14 days from today. And 14 days from that date that we file, the prosecution will file their response. And on the 18th of July 2025, the court will convene to give the parties the opportunity to adopt their various written addresses. And beyond that point, a date will be set for the court to render a ruling on the no case submission. Thank you very much for your support to the defense team, and thank you for keeping the peace. We appreciate everyone who stood behind us through thick and thin, and on behalf of the legal team and on behalf of Mazi Nnamdi Kanu, I wish to convey our profound gratitude for you all. Thank you.
All right, thank you.
No case submission in Nigeria. In Nigeria, whenever a person is charged with an offense, the person, referred to as the accused, can either plead guilty or not guilty. If the accused pleads not guilty for that offense, it is the duty of the prosecution to provide evidence that all elements of the offense have been committed, as well as to prove that the defendant is the person who committed them. Therefore, the burden of proof lies with them. The burden of proof in criminal trials is beyond reasonable doubt. During a criminal trial in Nigeria, it is the duty of the prosecution to prove that the accused is guilty beyond reasonable doubt. This is true to upholding the fundamental principle that everyone is innocent until proven guilty. If there is any possibility of innocence which still exists when the case is over, the court must acquit and find the accused not guilty. The process of a criminal trial has two parts. In the first part, the prosecution presents its case and calls its witnesses. In the second part, the defense presents its own case and calls its own witnesses. In both parts 1 and 2, the lawyer for the other side can cross-examine the witnesses which the party presents to give evidence. When can a no-case submission application be raised? At the end of Part 1, after the prosecution has finished presenting its case, if the defense feels that the prosecution has failed to prove its case, then the legal process in Nigeria allows the defense to make an application known as a no-case submission. When a no-case submission is made, it basically means that the defendant is asking the court for an acquittal without it having to present a defense. The defendant is literally saying to the court that there is no case to answer. That is, the prosecution has not sufficiently proven the legal threshold to establish the commission of a crime in the court of law. The submission is reliant on the strength, or rather, the lack thereof, of the prosecution's evidence. When used, the results are extremely beneficial to a defendant because, when successful, it means that the case effectively stops without the need for the defendant to call any evidence at all. The defense makes the plea by filing an application before the court, and if the judge agrees, then the matter is dismissed and the defendant is acquitted without having to present any evidence in their defense. If the judge does not accept the submission, the case continues and the defense must present their case. Therefore, because the defense really loses nothing by filing a no-case submission application, it is a very common defense tactic used in criminal cases in Nigeria. What is the standard for no-case submission? The general standard which the courts in Nigeria will use in determining whether a no-case submission should be allowed and the accused person acquitted is contained in Section 303 of the Administration of Criminal Justice Act 2015. It provides that the judge will consider four things. Whether an essential element of the offense has been proven by the prosecution. Whether there is evidence linking the defendant with the commission of the offense. If the evidence so far which the prosecution has provided is one that no reasonable court or tribunal would convict on it. Any other ground on which the court may find that a prima facie case has not been made out against the defendant for him to be called upon to answer. The standard which the court uses to determine whether a case should be dismissed on the ground of no case submission is not one of beyond reasonable doubt. The court, when determining this, has to decide whether a prima facie case has been made by the prosecution. Prima facie case here refers to the standard of proof under which the prosecution need only present enough evidence to create a rebuttable presumption that the matter asserted is true. A prima facie standard of proof is relatively low. Here is what happens when a no-case submission is successful. When a no-case to answer submission is successful, the case against the defendant is dismissed, and the defendant is acquitted. This means the judge determines that the prosecution has not presented sufficient evidence to support a conviction, and therefore, the defendant is not required to present a defense. A no case to answer submission is a legal argument made by the defense after the prosecution has presented its case. It argues that the prosecution's evidence, even if accepted as true, is not strong enough to prove the defendant's guilt. If the judge agrees with the submission, it means the prosecution has failed to establish a prima facie case, a case that would be sufficient to convict the defendant if no further evidence were presented. In a criminal trial, a successful submission results in the judge directing the jury to find the defendant not guilty, leading to an immediate dismissal of the case. In civil cases, a successful submission can lead to the case being dismissed against the defendant. This mechanism prevents defendants from being forced to defend themselves against a weak or insufficient prosecution case. It ensures that the prosecution bears the burden of proving its case beyond a reasonable doubt, in criminal cases, or on a balance of probabilities, in civil cases.